All right, so this is the last group of the morning, and we are standing between you and a delicious lunch. So let's get started. Hi. All right, so this is our legal tech lightning round number one. I am going to be your MC, aka Chris Anderson of TED style host for this round this morning. And so we're going to have a set of very interesting 10-minute talks from this awesome group of legal tech specialists. And this first group that's coming up is Margaret Hagan and David Colarusso, and they will be talking about AI for legal help, scouting legal issues to prevent life crisis. So, how many of us have had a legal issue or have had clients where that legal issue really just was a massive life-changing crisis? And anyone who's gone through a divorce has probably been able to relate. So Margaret and David will be talking about their work. Margaret is here from Stanford. She's from the Stanford Institute of Design. And David is from the Legal Innovation and Tech Lab at Suffolk University Law School. A little bit about Margaret. She's very passionate about adding more people's voices to this conversation. And I've seen it in action firsthand. She has a fantastic way of reaching out into the community and bringing people together from all walks, which is so important for this work. I asked each of our speakers today what robot they would build if they could build any AI in the world. And Margaret responded she would build a robot that writes law journal papers. Woo! I could have used one of those when I was a fellow here. And then David says that he has a soft spot for Robbie the robot from Forbidden Planet. It's a little bit, I think I'm a little too young for that, but and it's not, at first I was like, oh, is that the one that said, "Danger, Will Robinson"? And I was quickly told, absolutely not, you need to study your nerd history a little better. So, without further ado, please welcome Margaret and David.
Hi, everyone. And then Metin Eskili is also on our team. We wanted to recognize him. But we're going to do handing off slides back and forth, but we're trying to keep it pretty tight.
Of course, the elephant in the room, big data and the law.
Yeah.
Laughter.
Yeah. So we're going to talk today about a project that literally we're just starting in the past few months. We've been scoping it out, and we're really excited to present it here for your feedback and input. At the intersection of machine learning, using data to improve the access to justice crisis, and harnessing pent-up attorney power. So we'll talk about what our protocol is, what we're actually doing, the models that we're aiming to build, and some of the design work, the human-centered work that we're leading towards. So David will start us off.
All right, so the first thing we need to do is be clear about expectations. So let's take the example of open legal questions where people ask questions online. Is there some way that we can use machine learning to help with that? Well, the first thing to understand is that machine learning is just a model. And you have to understand what a model's limitations are, and we've seen some great work about that earlier today, in order to know how to use it responsibly. So the thing about models is that all models are wrong, but some models are useful. So you need to take that into account and know that what you're going to be able to do is you're not going to be able to build a machine learning model, especially in these sort of unspecified areas that we've been talking about, that's going to be able to understand everything that's going on and give you, perfect answers. So what that means is, wrong button. What that means is you need to have the model, the output of the model, be the start of the conversation, not the end of the conversation. So that is going to help specify how you use a model in a responsible way. So you might imagine if we're going to build a classifier, say, on some of these natural language questions that people have to legal questions, that you're going to want to not let that be the final decision. Maybe that's good at looking at population levels to figure out for staffing what type of questions you're having. Maybe it's useful for triage to get certain things to certain people. One of the problems that a lot of these services have is that a lot of people ask questions and they never get claimed by attorneys. So what if we could help make that process sort of algorithm as matchmaker? And then we've got to ask, of course, compared to what? And of course, as we've talked about earlier today, one of the big questions, one of the big issues is that people aren't getting what they need, however you want to make that measurement. So compared to what is not a very large bar to pass. So what does machine learning need in order to do something? Well, machine learning needs data, right? So, and specifically, if we're looking at sort of doing some natural language processing on some lay people's questions that may or may not be legal questions, we need to have labeled data. And that doesn't exist very well in that space. Maybe in the commercial space, you have better labeled data sets because you have pleadings, you have things that are structured, you have terms of art that people use. But when you ask just someone, what's your problem, that's a very different scenario. So we need someone with expertise to be able to go in and do that labeling. So I'll tell you a quick story. I used to be a public defender. I was a salaried employee, so I didn't have to take hours. I didn't have to do minutes. And one week I thought, let's see how long I'm waiting in court. I worked in a particularly busy court. I spent 19 hours that week just waiting. So it was a part-time job for me to wait. I now have a commute where I spend 10 hours commuting. There is a latent capacity that attorneys could use to their benefit. And so what we can do is get a scenario where we can access that latent capacity by having people crowdsource labeling. So what we want to do is we want to sort of make that robust so that instead of in the scenarios where you sort of, you might have heard about these studies where you have radiologists going up against algorithms and they say the algorithms are beating radiologists. Well, how do they know? What's the ground truth? Well, they compared it to the consensus with 4 radiologists. So what we want to do is we want to actually build something that's more robust, have a large community, and a good consensus algorithm that will help us figure out what the best labels are. What are we going to label? Well, we're looking at corpora like legal questions over in Reddit. We're not looking at the answers. We're looking at the questions, right? So these are the questions people ask when they're asking about questions. So there are sources like that, sources like things like these online help at the ABA. And then also we're going to look at professional resources, so things that courts put out. And we could have different sets of labeling under a common taxonomy, and then that maybe allows us to be able to figure out what that mapping is. So how are we going to do that? Well, glad you asked. I have one more slide here, which is that this labeled data, we want it to be the start of a conversation, so we want to do this in open. So what we want to do is we want to work as much as possible with open data sets and to share that labeling with the community, because that's the way we're going to avoid a lot of these bias problems and these unforeseen consequences if things aren't transparent. And so we're going to talk about the nuances of that a little bit more.
Yeah. So let me walk you through what exactly we're doing in our project together with Suffolk and Stanford. So right now we're in the process of gathering data sets of either where people are presenting legal help problems, mostly online, so from Reddit and then from some other sources, where people are talking about their life problems, maybe saying that they know what the legal issue is, but we know as lawyers that oftentimes they don't necessarily know how to self-diagnose. And we're also scraping legal help websites that courts, self-help centers, and statewide legal help websites put out, where there's lots of actually very good DIY resources, but they're not very findable or discoverable right now. So we're gathering both of those data sets, and we're developing a crowdsourcing labeling tool for lawyers and law students, other legal experts to use. It's called Learned Hands. We'll give you a preview of it in just a second, where we can get a scaled up community to label all of these data sets. We'll release these in an open way as much as we can for the wider community to then use to hack on or to build from as well. And then we ourselves are also really interested in training machine learning models based on the labeled data so that we can think about building classifiers that would diagnose people's legal issues, that we can match online, public, court-based resources to people who are asking the questions, and that we can also do really good design work about how we build these new tools in ways that don't totally creep people out, that they actually trust and they want to use. So, this is where we came from, drawing from in 2012 in the back of Tort's class. So Learned Hand is our inspiration for the name for our crowdsourcing tool. David has another pun. He's very good at puns. There should be a fourth hand on there that's not a hand at all, but the invisible hand, but coming soon. So you can go and see our working version of a crowdsourced labeling tool. And we have a data set of scraped court websites, resources on there that you can play around with labeling. Everything you do is not actually going to be saved. This is just a prototype of what a gamified labeling tool might look like. Here's a GIF. So we have different snippets of text. Metin Eskili, our brave software engineer, has developed this just in the past 3 weeks. We have snippets of text. We have labels based on a working draft of an ontology of the major civil legal aid issues out there, about 800 issues that we have documented. We're going to be refining that. But you can go to this website, play around. We're trying to make this as fun and game-like as possible, so lawyers will get a little bit addicted to labeling issues for us. We have a slow mode and a fast mode. We're really trying to figure out ways that we can scale up access to justice, machine learning, and resources. So feel free to go leave us feedback. We really want your input. We're at very early days, and we want your criticism about how to make this tool as fun to use for lawyers as possible. And as we do this, we're also training models to then take on common queries, how people are phrasing questions on Reddit or on Google or other places, and seeing if the model can diagnose at least a high-level family law issue, if not the specific family law of like a specific type of divorce or specific type of custody question. But as the labels come in, we're going to start training the models and see how quickly we can get towards something that looks like a classifier. I'll hand it off to David.
And so why are we talking to you now? Well, before we've started, it's because we want to make sure we don't stumble into any, morasses of problems. We want to know what you think are the issues going forward. And we also want to think creatively about how we can engage the community to do something like this. Can we get CLE credit for doing pro bono labeling? If there are any bar members who are in a position to help with that, talk to us. Also, if you have data sets that might be useful for labeling, we'd like to help with that as well, too. So we're trying to involve the community. We're trying to work in the open so that we can make sure that we end up with a product everyone's happy with, and done in an ethical and transparent way.
Yeah, the other main concern that we're interested in is, we'd like to think that lawyers can really be great leaders when it comes to developing these new machine learning-based or otherwise intelligent tools. I think we're a little bit nervous that people who are maybe not as cognizant about the ethics and the user's issues might be building tools like this before we as lawyers do. So we're trying to take this very design and also lawyer ethics approach to developing these new AI tools, really putting people at the center. And at the same time as developing the models, also thinking about where do people actually want to have their legal issues diagnosed. When we do preliminary focus group testings of having a Twitter bot that messages people, oh, based on your most recent 50 tweets, we think you might have a housing issue. We recommend that you go seek out help from your local housing nonprofit. It might be well-meaning, but people get totally freaked out. So when we actually put people at the center of the design of new machine learning, we can really focus on what do people trust, what gives them dignity, and what gives them control. We've all seen the scandals over the past several weeks. When people are profiled, things are predicted, data is used in ways that really profoundly disturb people. And especially around legal issues and life crises, these are really moments when people are very vulnerable. So how do we test, vet, and put people at the center of actually designing these new smart tools? This is one of our major focuses. So we just have a few asks of you before we cede the floor.
So really, this is sort of what I talked about before. We're looking for, what are those, if you have data, if you have thoughts on how we can work together, talk to us.
Yeah. If you have any data sets that you think might be of use to this, we're really interested in talking more to you. And yeah, go check out the tool, play around with actually labeling data, tell us if it's fun or not, if it feels rewarding or not.
And remember, many hands make light work.
Those were the puns. Thank you all. Yeah.
Thank you for that, guys. That's so interesting. And just a final note on Robbie, the robot. Apparently his most famous quote is, "Quiet, please, I'm analyzing." So moving on now to Metin, who's also part of the same team. His background's very interesting. He's a software developer now dedicated to legal work, which is, I think, probably one of the most important things for this whole ecosystem is for software engineers to understand the point of this, the socioeconomic meaning of this work, and commit themselves to what is really a unique challenge. And so you talk to some of the top NLP researchers, and many of them will say, legal intelligence is one of the highest formats of machine learning in relation to natural language. So I'd like to welcome Metin up here to give his talk. He's currently training. Oh, I'm sorry?
Oh, he's not talking.
No?
Part of our food.
Oh, okay. I'm sorry about that. I didn't get that note, but thank you so much for your commitment to this work. Okay, so our next talk is Bart Verheij, who's in town, I believe, from his home in Amsterdam. Is that right? Grody, okay. And so he'll be talking to us about why we need to bridge data and knowledge technology. So he wants to make computers understand us and our lives well enough for them to do proper legal work. And anyone who's worked with some of these legal tech tools, they're not always right today. They're right a good portion of the time, and that makes that exciting, but oftentimes they get things horribly wrong. So how are we going to bridge that? And we don't really know yet, but there are many professors working on this issue and fine-tuning these tools so that they're right all of the time. Because when you get a legal question wrong, the downstream impact is hugely serious. So his AI robot, he'd like to build an AI robot that can do discovery and invention, then build a proper legal AI robot. So he basically wants to build a robot to do his job. Please welcome Bart.
Thank you, Nicole. So indeed we live in exciting times. Our world is changing fast, and as always, significant changes come with fears and dreams. So I speak of the final frontier of human knowledge, artificial intelligence, of which the invention is ongoing as we speak. So real artificial intelligence that can match ours. As yet, we don't know how far we'll be able to take that, and we don't know what the consequences of its invention will really be. Will our happiness increase by the continuing delegation of tasks to machines and robots? Or will it decrease as we will find our roles in the world ever less relevant? Will safety increase by the rise of data-driven policing? Or will it decrease by robot warfare? Will our autonomy as citizens increase by the growth of technological possibilities, or will it decrease by the growth of ever more intrusive institutions? Nobody knows the answer to these questions. But we are here and experiencing the invention of artificial intelligence. And better yet, we are the inventors. These are good times. I mean us here in this room. We are working on that. For that is my main message today. Real AI can only be invented by taking the law and its peculiarities serious, as we all do here. And that is what researchers in the field of AI and law have been doing for several decades now. Inventing the AI that can do law, that can follow past cases and apply existing rules, that can produce arguments that solve concrete legal puzzles and thereby gradually change the law. Not surprisingly, this is quite a daunting task. Since in the law something matters that has proven to be hardest to conquer for AI research: the understanding of our large and complex world. As yet only people are good at that, not machines. Here I assume that you agree with me that real AI does not yet exist. You will have heard of the disruption of legal institutions, of machines predicting court decisions, and of the automation of jobs that once only could be done after completing a good law school. Still, these well-known future law themes are prospects for the future of law and do not describe today's law. To explain a little bit about the state of the art, let me discuss the AI and law success story that is possible today in my country, the Netherlands, where significant parts of legal administration are heavily automated. In particular, I think of filling out tax forms, which has become close to child's play in my country in recent years. For a large proportion of the Dutch population, completing income tax forms nowadays comes down to not much more than checking whether the information that the tax administration has already collected is correct, perhaps filling out a few omissions here and there. This is possible since employers, banks, local governments already share and in fact must share most of the required information. This highly automated system implies a transparent, reliable, and equal tax collection practice. And what technology allows for such a significant success for AI and law? Well, the first ingredient for this success is what is called knowledge technology. The kind of technology that allows for the representation of complex human expertise in a format that can be understood by machines. And typical knowledge technology uses a format of rules, explicating which conditions determine a legal outcome. So think of the rules that specify which parts of your income and wealth are taxable and how. The software that the tax administration has developed, accessible for all citizens in a standard web browser, has tax law knowledge in the form of a carefully developed set of machine-readable rules, hence the term knowledge technology. And the second ingredient of this success story is data technology, the kind of technology that collects, analyzes big databases from all kinds of sources. Typical data technology uses tabular data, much like what you see in a large spreadsheet, specifying legally relevant information. Think of the data about your salary, bank assets, loans. In my country, employers and banks collect such data, share them in a specific prescribed format with citizens and the tax administration. And when preparing your tax form online, this information is already filled in. The example of Dutch tax administration shows intelligent legal tech that has expertise about a specific complex topic, infers reliable legal consequences and is grounded in real-world big data. In that sense, it is artificial intelligence in real use today, but it is also clearly not real artificial intelligence. For the software's expertise is very specific and limited to the fixed setting of tax law without any sign of the wide scope of general human intelligence. Also, the software does not autonomously adapt, for instance, to changes in tax law, which happen all the time, but follows a fixed set of rules that only change when its makers decide so. And finally, the software does not autonomously grow its expertise beyond what it already knows, as we expect from any lawyer or any other professional. And these properties that are missing for the tax law example are right now not technological limitations per se. Today's artificial intelligence can have general knowledge, it can autonomously adapt to a changing environment, and it can autonomously grow its expertise. You probably have heard of the corporate technology that won a general knowledge quiz show a few years back, and your email filters autonomously adapt to new kinds of junk mail, and search engines autonomously grow their expertise by reading new online encyclopedia entries. Each of these properties is connected to data technology in the sense of machine learning. That is all true. But what is not true is that these properties of generality, adaptivity, and growth can already be realized at the level of a complex and sensitive task, such as tax administration. There are 3 reasons why. First, this intelligent kind of data technology is not corrigible. It cannot be corrected. For instance, our phones track our whereabouts and classify the means of transport that we have been using. I don't know whether you know that, but we all have these smartphones and they do that. Often this is done correctly. For instance, in my case, many train trips are in fact automatically classified as trips by train, but not always. Some train trips are classified as biking trips, even though biking more than 100 miles in 2 hours is clearly not possible. Second, the technology is not explainable. We have already heard that this morning. For instance, neural networks can be trained to recognize capital letters A, but when a neural network is trained, it has no way to explain why it thinks that some letter is an A. It has no concept of a capital A as a figure that consists of 2 bars that meet under an angle at the top and that are connected by a horizontal bar. And third and finally, this technology cannot follow normative guidelines. An example is a software company's chatbot that went online and adapted its style to the conversations it had on the open internet. Already a few hours later, it had to be taken offline as the automated dialogue had become so unpleasant, so rude, so offensive, just like the examples the bot had seen online. For knowledge technology, these properties of what can be called good artificial intelligence are feasible. Knowledge technology is corrigible, is explainable, and can be normatively guided. So what is needed for the next level of AI is to keep the best of different worlds. We want the complex expertise, the reliability and grounding in big data that is already operational in Dutch tax administration. We want the generality, adaptiveness, and growth of big data technology. And we also want the corrigibility, explainability, and normativity of good knowledge technology. The thing is, nobody really knows how to do that all simultaneously. The only intelligent systems that we know that can do it all are we ourselves, humans. Machines can have subsets of these properties, but not all at the same time. And we simply don't know how to do it in machines. But in the law, we see how to connect data and knowledge. Data comes in the form of cases, decisions that can be followed. Knowledge comes in the form of rules as they are codified or restated. In the law, the connection between knowledge and data is made in the critical, adversarial, legal process. Cases are not always followed, but distinguished from, as circumstances demand. Rules are not always applied, but can have exceptions in new situations. Hence the plea for the development of a new kind of AI based on argumentation, critical thinking, critical reflection. In such systems, hypothetical answers to problems are constructed using rule-based knowledge and tested in case-based data, much like what we see in legal decision-making every day. In the field of AI and law, such argumentation technology is being developed. And in Groningen, that's where I live, we are currently working on new mathematical foundations for such technology. I believe that that is needed. I'm a mathematician by training who has ended up in this interesting field. And inspired by the need to bridge the logic underlying knowledge technology and the statistics underlying data technology. And we already also in this morning saw some of the puzzles that come with that. In this way, we are developing a technology that can think critically in order to develop an understanding of our complex world. And we are thereby working on an AI that is at the same time complex, reliable, and grounded, as in operational legal technology already today, general, adaptive, and growing, as in big data technology, and corrigible, explainable, and normative, as is the case in good knowledge technology. And by that, more dreams will be realized, less fears will come true, since argumentation-based AI is not only operational and learning, but it is also good by its embedded critical reflection, much like what we see in the law all the time. Thank you for your attention.
Okay, thank you, Bart. So I learned yesterday that there was a document leaked from Facebook regarding how much the two campaigns spent in comparison. So for Hillary's team, they spent $22 million to Facebook for the campaign, and Trump's team spent well over $43 million. It was also leaked that the Trump team knew how to use the Facebook platform to access personal information and do look-alike modeling of individuals, such that you really didn't need that much information for very specific individuals, but you could learn about them by classifying them into different categories and using clustering technology. So our next speaker is very dedicated to exposing to internet users in a way that they can digest the meaning behind those terms that you accept when you engage in these social media platforms. She cares very deeply about empowering people, about privacy through design. So as all of us know, these terms of service are virtually impossible to truly understand, even though Mr. Zuckerberg has said, well, you should just assume that your public profile data can be used by people however they wish. And I think that assumption is going to be challenged. It's certainly being challenged now, but I think part of our role here is to look very deeply into that issue. So welcoming Arianna, and her AI robot would, I don't know if I have this right, but somehow know what music you want to listen to at all times and play it ambiently through your head. Yeah. Okay, thanks.
Thanks a lot. Rossi, could you put the presenter here?
I'll show you.
On the perfect.
Let me switch on there real quick.
Yes. Okay. Thank you. Good morning, everybody. My name is Arianna Rossi. It's not showing the, okay. My name is Arianna Rossi, and I am a PhD candidate in a joint international program from Europe, which is called Law, Science, and Technology. And we were speaking earlier about legal education and technological education. And this is, let me spend really a couple of words about this, because it's a very great program that allows us to travel around Europe. Every 6 months we change university and we change country. And this is why on my slides you see that there is the University of Bologna in Italy, which is my home university, but also the University of Luxembourg, which is where I'm currently staying. And today I'm going to introduce very briefly my PhD project, which is about design and legal design, specifically applied to the data protection sphere. This is a very topical time for data protection, because I'm sure that many people in the audience know that the GDPR, it's the General Data Protection Regulation, which is coming into force in May 2018, and is part of a very, very wide data protection reform in Europe, which has a very wide scope, because it will apply not only to European businesses, but also to businesses worldwide that offer goods and services to European citizens. And huge fines are introduced by these regulations, so there is a very high interest for this. And I would say that one of the main goals of this regulation is to try to introduce a new balance between data subjects, users that give their personal information, and businesses, companies, and institutions that harvest this information and use and process it. We know that this relationship is rather imbalanced right now. And in my project, I am tackling a very specific problem, which is the one of information asymmetry, which is also known as the biggest lie on the web. Are you all familiar with this situation? I will give you a couple of seconds to read this privacy policy. It is a real privacy policy, and it is written in Latin. Well, it's a lorem ipsum thing, right? It is real. It is from an Italian educational institution. It was up there for a lot of time. Why? Because nobody reads them, right? And even if we do read these documents, they should actually inform us about how our data is used and for which purposes and what we can do about it. Even if we actually read them, we do not actually understand them, because they're really long and complex documents, and they're also really tedious. And nevertheless, we are considered informed, and our rights have been upheld like that. And we are considered informed and capable of having choices about how to use our data, whether to use a service or not. However, we know this is not true. But the GDPR is trying to actually rebalance this relationship, and also to give us more power about how to actually understand this information. And in fact, there is a new obligation that is introduced by the GDPR, which is that of transparency. We've heard about algorithmic transparency earlier, but I'm actually talking about information transparency. And there is a very big push towards information transparency in the sense that right now privacy policies are there only because there is this legal obligation, but nobody actually cares about how they're written and how they are presented. And right now there is a new obligation which also introduces fines, and it's really also encouraging people and policy drafters to use new methods to communicate privacy. And also with Margaret, other co-authors, we have looked into these, and we've seen that there are not many experiments around the world, but there are people that are trying new ways to actually understand how to communicate in a more effective way. There are gamified experiences, there are videos, there are AI-powered summaries, there are chatbots, there are many experiences. But with my research team at the University of Bologna, we have focused on a very specific design pattern, which is that of icons. Icons for data protection, because it is the regulators that suggest icons to give a meaningful overview of the intended processing. So not only text, but also visual elements. And what we did is that we ran a series of legal design workshops, the first of which last year here in Stanford, and then others in the last few months in Bologna. And the legal design workshop is a workshop where mostly designers and lawyers, but also many other professionals meet, and they tackle a very specific challenge. For us, it was that of creating icons for complex, abstract and unfamiliar concepts like those of data protection. And it was a very interesting experience. Of course, there was also a lot of tensions between very different mindsets, because designers usually want things to be easy, simple to understand and to use. They go for functionality and usability. Whereas lawyers make things usually a bit more difficult in the sense that they want things to be precise, and they want also visual elements to be really informative, as the text can be. So it was a very interesting experience, but I think that the best thing is that usually law defines how things should work, and designers can really help in the thing that they can find ways to make things work. So for example, people should read privacy policies, but they don't. So let's find ways so that they do. Or people should write transparent privacy policies, but they don't. So let's find ways to do so. And what we did in the end is that we produced a data protection icon set that was developed around some conceptual cores of data protection law. For example, the rights of the data subjects were really highlighted, because usually, right now, they're not really highlighted in privacy policies. There are new data subjects' rights that are introduced by the GDPR, but also other conceptual cores like the legal basis for processing, the kind of processing operations, and the processing purposes. And as you can see, it is kind of a network. Indeed, we modeled this data protection icon set on an ontology, which is being currently developed at the University of Bologna and the University of Luxembourg. It's an ontology for privacy and data protection concepts. So it's a formal model of this domain knowledge. You can do a lot of things with it. If you add rules, you can also draw inferences. And it is a description of concepts, of their properties and their relations among them. And one of the possible applications is that you can extract meaning from natural language text and map natural language to a conceptual formalization of this domain knowledge. And this is particularly interesting in the sense that we have also mapped this ontology to our data protection icon set, so that we can automatically retrieve the icons in the relevant spans of text of the privacy policy, so that you can actually visualize these parts. Indeed, icons in in many studies and in other studies in the legal sphere have been proved to be very useful elements to make people understand better legal terms, to make people navigate through the text in a more effective way, to make people memorize information. So we're using these visual elements because what we want to do is to pass from a privacy policy written in a dead language into something that resembles more this, has information architecture, there are visual elements, something that makes more sense for the citizen, for the normal person that does not have the legal knowledge to actually understand all of the privacy policy. So this was a very, very brief overview of our project. It is being carried out at the University of Bologna, at the University of Luxembourg. And if you're interested, I would be really happy to give you more information. You can write to me. I can put you in contact with my research team, and we can also have a talk later during lunch. Thank you very much.
Thank you, Arianna. I was thinking you could even just put like an unhappy sign over really negative privacy policies and just, it's like, don't do it. So our next talk is by Ashkon Farhangi, who was inspired to join this mission after taking the legal informatics course created here and taught here by Roland Vogel and Mike Genezareth. And so, huge win, woohoo, good job. Just highlights kind of, this group here, and really, I describe it as the mothership of legal tech. So this is the mothership conference, in case you didn't know. So I'd like to welcome him here. He's going to talk about automating the citator to improve access to the law. And the idea is, how can you get these citations to individuals that can't afford proper counsel? And so we'll hear from Ashkon on that. Welcome up. Please welcome him. Thank you.
Great, thank you. And thanks, Nicole. So hi, everybody. Like Nicole mentioned, my name is Ashkon. I'm a master's student in the computer science department here at Stanford. I'm also a fellow at Codex and a product manager at Google. And today I'm going to be talking about a project I've been working on for the past few quarters that involves applying machine learning to the law. So hopefully my slides will show up soon. But in the meantime, I'll get started. Great. So I'll start with a little bit of background that the lawyers in this room definitely don't need, but some of the technical folks in the room, like myself, might benefit from. And so when lawyers are making arguments, they often use precedents to support the arguments they're making. And obviously, doing so is only valid if the precedents they're citing have held up in court. And that means that any precedent that a lawyer might want to cite that's subsequently been reversed or overruled will not hold up in court and will tank the lawyer's argument. This is pretty obvious. The challenge is that there's no sort of government database that lists all precedents and whether they have been overruled or not. And so if you on your own wanted to go out there and sort of determine whether your precedent is valid, you'd have to read every subsequent judicial opinion that's come out and verify that it has not, in fact, negatively treated the precedent that you want to cite as a lawyer. Now, the good news, obviously, is there are services like Thomson Reuters Westlaw and LexisNexis that provide this information, and they actually do it accurately. They do a very good job. So in light of that, the question is, where am I going with this? What's the problem? And the answer is that they're unfortunately a little bit expensive. And so this is not a huge problem for some folks, but it is for others. And in particular, they're expensive because they have on staff teams of lawyers whose full-time job it is to read pretty much every judicial opinion that comes out and to flag within them the precedents that they're negatively treating. And this is not a huge problem for the big law firms, the fancy lawyers who can afford these services, but for maybe the individual practitioners or the smaller shops that are serving, in particular, clients who don't have a lot of money to pay for legal services. Sometimes these services are actually cost prohibitive. And what ends up happening is that they end up flying blind. They don't know if the arguments they're making are going to hold up in court. And the people who really end up paying the cost of this are the clients of those lawyers who themselves cannot afford to pay very much for expensive lawyers. And so this is really an access to justice issue, in that it's one more reason that clients who can't afford to pay very much for their legal services are going to be less likely to have a fair outcome in court. And so in light of this, when I heard about this, I thought maybe I can mitigate the problem a little bit by applying my NLP and machine learning background to sort of automating the task of identifying negative citations so that lawyers don't have to do it and the services that provide that information can be a lot cheaper as a result. But I wasn't the first person actually to look at this problem. And in particular, I want to give credit to a company called Fastcase, which is here. Hey, Jeff. And they built a product called Bad Law Bot, which basically leveraged the insight they had, which was that a lot of negative treatments are mentioned subsequently by other judges who refer to them in their judicial opinions. And in particular, the Blue Book mandates that when they do that, they have to do it using very formulaic language, in a particular select number of phrases. And so what Bad Law Bot was able to do is basically deploy a system called regular expressions, which for those with less of a technical background are basically deterministic programs that identify very formulaic language patterns to identify these places where judges are talking about previous negative treatments in these really formulaic ways. And they were able to do this with extremely high precision. You know, it was almost 100% accuracy within the set of negative treatments that they were able to identify this way. But this is not a perfect approach, and that's because it turns out that the pretty significant majority of negative treatments are never actually mentioned by judges in this particular way. And so this approach is not able to identify the vast majority of negative treatments. And so my work was to basically build a machine learning system that would expand upon this idea and generalize to hopefully every language pattern and not just a select few. That being said, Bad Law Bot's insight actually turned out to be very useful in doing so. And that is for the following reason. Whenever a machine learning system is built at a very high level and very oversimplified terms, there are sort of like two broad components. There is the algorithm, and then there's the training set. And this was alluded to in an earlier talk, but it turns out that training sets are not always easy to come across. And this is kind of a shame, because when people talk about machine learning, they typically talk about the algorithms, they talk about the LSTMs, the deep learning, the neural networks, all these great buzzwords that people love to throw around. And when you take a machine learning class at Stanford and you walk into the room that's like overflowing with 1,200 people because machine learning is like the hottest thing in the CS department right now, chances are that the professor is going to do 9 times out of 10 the following. They're going to give you an assignment that involves giving you the data set, giving you what you're supposed to predict, and then asking you to write the algorithm that actually uses the data set to learn how to predict what it's trying to predict. And that's great. It teaches you how to sort of understand the mathematics and the theoretical underpinnings of the algorithms you're learning how to build. But it's not representative of machine learning in the real world, in which finding the data set is often half the battle. And unfortunately, this real world situation was no exception. And so the first battle was finding a way to find a training set that I would subsequently use to train a machine learning algorithm. And the way I did that was using the Bad Law Bot sort of insight that one can build a set of regular expressions that identify a small, relatively small subset of negative treatments that I could then use to train a machine learning algorithm to generalize beyond that small subset. And that's what I did. And so I don't want to get too deep down the rabbit hole of all the technical details of the algorithm that I built, because I'm sure a few eyes would glaze over in this room. But I will mention a few things just for folks that may be particularly interested in that. And in particular, I'll say first, it was not just a single classifier. It was actually sort of like a graph of multiple classifiers that were all feeding into one another. Second, I'll say the featureization algorithm that I was using was primarily based on dependency parse trees. And in particular, it turned out that subject, object, verb tuples that you can sort of extract from syntactic and dependency parse trees turned out to contain a lot of signal for this particular problem. And lastly, I'll say that the algorithm I was using was actually not what you'd expect, which would be like a fancy LSTM or something like that. And it was actually a very simpler support vector machine, because it turned out, for reasons I probably don't have time to go into right now, that neural networks only performed a little better than the support vector machines in this particular task. And they took like way longer to train. And my AWS fees were getting out of control, so I shut it down a little bit. Cool, so really quickly, before I wrap up, if you tuned out, feel free to tune back in for a second. I want to talk about how this actually did and what the outcome of this project was. And in particular, I'll talk about two metrics, precision and recall, by which machine learning systems and classifiers in particular are typically judged. And so in this case, precision would represent the percentage of the negative treatments the system picked up that were actually correctly classified as negative treatments, and recall would be the percentage of all negative treatments in existence that it was able to actually pick up. And so quickly, I'll compare the system that I built to the regular expression-based system that I also built to train the system. And so that in terms of the regular expression-based system, it first was able to achieve pretty close to 100% perfect precision. And on the recall side, it was able to achieve a little bit less than 5% recall, actually, which is not great, obviously, but good enough to train the system. The machine learning system, in contrast, was able to achieve a little bit less precision. It was greater than 95%. I won't give a specific number just because there are some nuances in the evaluation metrics that I don't have time to go into. And on the recall reason for the same side, on the recall side rather, for some reason, it was able to achieve more than a 60% total recall. And so what that means, net-net, is that in exchange for losing a couple percentage points of precision over the regular expression-based sort of training system, it was able to identify more than 10 times as many total negative treatments. And so obviously this is not perfect. No machine learning system typically is. Machine learning, the system included, is not going to replace lawyers tomorrow. And depending on your perspective, that's either a good thing or a bad thing. But I think it's promising, and it certainly was a lot of fun to work on. I'll continue iterating, hopefully making improvements, and I look forward to doing that. I hope that it'll be fun at the very least. So really quickly, before I wrap up, I'd just like to thank a couple people. And first, I'd like to thank Pablo Arredondo, who's going to talk later, for giving me the idea for this project to begin with. And I'd also like to thank Professor Nazareth, who I think you all know, for his support. So with that, thank you very much for listening, and I'll hand it off to the next speaker.
Thank you. So our last talk for the session is about measuring legal innovation from Dan Linna. So Dan's going to tell us if we're going too slow, right? Speed up. Dan is an affiliated Codex faculty, professor of law in residence, and director of legal R&D, the Center for Legal Services Innovation from Michigan State University College of Law. And he believes that all lawyers need to stop protecting the legal profession and focus on serving the public. Thank you, Dan.
Thank you, Nicole. So I was at this conference 2 years ago when Jim Sandman gave a really great keynote on how to move the legal industry forward. See if I can get this. Okay, looks like there's a... There we go. Okay. Let's try that again. 2 years ago, when Jim Sandman gave the keynote talk here at Codex, Jim Sandman, the president of the Legal Services Corporation, he talked about 10 ways to move the legal industry forward. And one of the things that he talked about is that we need to stop ranking law firms based on revenue and profit, and we need to rank them based on their adoption of technology. And when I was sitting in the audience, I thought, well, this is a great idea. Someone is going to jump on this, right? But yet, 1 year ago, here is Jim sitting quite distressed here at the Codex FutureLaw conference because no one took him up on this idea. And I decided right then in the audience that this is something that I wanted to take on, that I wanted to do. So I went back to Michigan State, and I got some students together to work on this project, including our innovation fellow, Jordan Galvin, who's here, and students Sean Acosta, Andrew Burgess, Jameson Joyce, Shelley Reed, and Anita Western, and decided we were going to work on this project last summer and pull together a minimum viable product. Right, so this was something we could have spent a long time working on, but we wanted to apply the same innovation principles we're saying others should be applying to this problem. You know, where are we trying to go? We wanted to have a measure of legal innovation. Where are we now? We have nothing. What are the obstacles getting there, right? Let's start collecting the data. Let's start building a model so we have something to work with. Why do we want to do this, right? I want to move the industry from opinions, anecdotes, and intuitions to relying on data. Everyone has an opinion about what's going on in the legal industry. They think law firms aren't doing enough. Some people say that law firms are doing a lot and we're going to see disruption. Well, let's get away from that and actually capture data and try to measure what's happening. Let's introduce transparency. Let's raise awareness. Let's foster accountability on behalf of lawyers. And let's empower consumers by making this data available to everyone. All right, so the minimum viable product here consists of 3 pieces: a law firm innovation catalog, a law firm index looking at 260 law firms across 260 international law firms, and a law school innovation index prototype. And this is all available at legaltechinnovation.com. It's Tableau. All the data's in Tableau there and available, and all the methodology is there. And it's hosted by LexBlog, which I appreciate and give them a shout out. So starting off with a catalog, and we see articles and books that talk about innovative law firms, but no one had really undertaken the task of curating this information and trying to categorize it and put it in one place. So that's the first thing we did, is trying to go and look out, and here I have a whole list of resources. So we started pulling this together and figuring out how we organize this information to make it actionable and useful for folks. And Carla Swansberg at Blake's in Toronto was also very helpful by contributing a lot of research to get us started with the catalog. So we categorized it by what innovations are products, what innovations are new services, what innovations are consulting products, and then also by geographic region. I'm going to go through this kind of quick, but I just want to give you a taste for it because, again, it's all available on the web. Breaking it down by area of law, which has been helpful for law students and also folks in law firms and customers to be able to say, okay, within this subset, what's actually happening across the industry? And then also trying to look at the tool and discipline that's driving these innovations. I mean, is this an AI tool? Is it an expert system? Does it have something to do with project management? And then I've got a table of all this broken down by law firm and allow you to drill down further on it. So for example, here, you can look at the Ackerman Data Law Center. It's an expert system. It's a partnership with Thomson Reuters and Neota Logic, and then I have a short description of each tool and a link to the website so you can learn more about it. So that's the catalog of innovations, and there's also a forum on the website for law firms to submit innovations, because we want to try to keep populating this and make sure that it's available to get a sense for what's actually going on across the law firms. But of course, that's only the firms that we know that are doing something. So how do we actually come up with a measure across the industry? And fortunately, when you talk about law firms, they all have websites. And they're all marketing their wares on websites. So if they're innovating, you'd think, well, they're going to talk about what they're doing on their website. So I put together a list of 260 law firms, the AmLaw 200, Canadian Top 30, and the Global 100. Now, this is not a ranking, right? We're just trying to measure and get a sense, what are law firms doing in terms of innovation? So the first thing you had to do is come up with buckets, but different buckets of innovations, and then search terms. And I won't bore you by reading these all off, but taking these search terms then and using Google advanced searches and running them across the website to get hits, number of hits within each of these buckets. Before I show you the data, I will note that, of course, so David stole my line about some models are, all models are wrong, some models are useful. Why is this useful? Well, it's a proxy. It's a proxy for what law firms are actually doing, right? That you think they'd be talking about the innovation that they're undertaking on their website. There may be a gap between what they say they're doing and they're actually doing. They may actually be doing things and not talking about it on their website. Why? I don't know, but anyway, there may be a disconnect there. The thing I really want to hammer home, though, is, we teach these classes in our curriculum at Michigan State, and I really believe, real innovation is going to require organizational change. So not just a couple of projects here and there. But again, I think this is a proxy for this, right? If you see hits on this, you would think that you're building a learning organization. You're building an organization where you're actually empowering everyone in the organization to innovate, the people who are closest to the work especially. Right? So we want to make sure we don't lose sight of that and get focused on the measure and not the ideal for what it takes to actually innovate. So I've got breakdown of these different tasks. We are a little surprised at blockchain we had a high hit, but this was a little bit of an artifact of some false positive perhaps, because you have blockchain departments and groups and things like that, you'd have more hits. But other lines and things in line with expectations, project management getting a lot of hits. We've been talking about this for a while, and you've got the ACC and Clock talking about wanting to see law firms use project management, disciplines like that. Got some breakdowns by different geographic regions. We hear a lot of anecdotes about the UK being ahead of the US, for example. You compare the Global 100 and the AmLaw Top 50, and you see that there are more hits here. On the pink part of this is project management, and the orange part, artificial intelligence, right? So a little bit of data that seems to be in line with our anecdotes about the UK being ahead on some of those topics. And then you can look up your individual law firms. So those of you who are from law firms here in the audience, you can take a look, see the number of hits. You can tell me at the break, I guess, if you think it's in line with your expectations, and tell me whether the model is on. And broke that down into a 0 to 10-point scale for each law firm, all 260 law firms. Okay, so this, I know I have to admit I was a little bit sheepish about the amount of attention that this got, because I thought, okay, well, I think this is a worthwhile endeavor to start trying to measure this, but it really got picked up. And that encouraged me to take the next step and apply this sort of thinking to law schools, right? How do we figure out what law schools are doing? And it drives me crazy. I go to these industry conferences and people want to everyone's always pointing the finger at someone else, right? Someone else is creating the problem in the legal industry. Law firms deserve a lot of the criticism they get. However, there are some that are innovating. So how do we get beyond just these anecdotes about law firms being the problem and actually measure what's going on? Okay? So what I wanted to do is look at the law schools that are recognized as innovative. And initially I thought I'd have maybe 15 or 20, but it ended up that it was 40 that had kind of been discussed that are doing innovative things. Sometimes we hear about law firms being innovative because maybe they're talking about the law that applies to entrepreneurs or something like that, right? But I was like, well, I don't really want it. That's a part of having an innovative curriculum, but what we're looking for is training lawyers to be innovators, right? So we want to really focus on legal service delivery, innovation, and technology disciplines as part of the curriculum. So I put together a model with 10 different categories of legal service delivery, innovation, and technology disciplines, and wanted to look at these innovative law schools and see the extent to which these disciplines were being taught in classes in law schools. And then I did also want to see these law and technology courses also look the extent that those are being taught, right? Those are a complement definitely to legal service delivery innovation. Okay, so we look at this and we get a sense for which of these disciplines are being taught at those 40 schools. Same thing with the law and classes. And then in this next picture, this is just a measure. Out of those 10 disciplines, which of them are being taught at schools? Now, I emphasize this is not a ranking, right? This is a little bit of a blunt measure. It's a first step. Is it being taught at all? We're not measuring how many credit hours, how many times the classes are being offered, and things like that, how many students. I'd like to do that in future versions of this. And then you can drill down, like here's Stanford, for example. You can take a look and see which classes are actually taught. You can see that they have programs, Codex, the Center on the Legal Profession, the Legal Design Lab. And so again, we're really trying to empower consumers here. I want to empower law students to start making smarter choices about going to law schools that are preparing them for the future. All right, so what's the next step? Well, the thing I want to focus on today, especially given what ABA President Hillary Bass was talking about this morning, is wanting to have an innovation index for law schools. I want to get all law schools on this index. And so I launched a new site, just an updated site yesterday with LexBlog. It's the same place, Legal Tech Innovation. And we built out the form to capture these innovations. So I want to get every law school around the planet on this index. And we designed the form so that right now we've got the law schools actually listed for the US, Canada, and Australia. We've got an other category. I'd like to get all of them listed eventually. But we're going to get a little bit more in-depth information, actual teaching of these classes over the last 2 years so we know the number of credits and the frequency with which these classes are being taught, and so on. Right? And then also just seeing what kind of programs they have. And of course, there's different structures for the way law school is taught in different countries. So we'll have to figure out how to kind of make sure we have apples to apples comparisons across the board on all of these. All right, so again, we need to get away from opinions and anecdotes about what's happening, and we need to start measuring. And I really would urge us all to really stop with these platitudes about access to justice and innovation. We need to really get disciplined. We need to measure our progress. We need to hold ourselves accountable. And I think if we do those things, we can move the legal industry forward. So thank you.
Well, thank you, Dan, and thank you to all of you guys for the work that you do. I have to say, I've never actually done this MC role before, and it's a lot harder than I thought it was going to be, because you really want to do, the work you guys do justice, pun intended. And so please enjoy lunch. That's what's up next, and I hope you can attend our afternoon session. It's sure to be thrilling. Thank you very much.